Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. Thank you as always for joining us as we approach the 250th anniversary of the United States of America. God bless America. In the meantime, the Supreme Court is going to give me a heart attack because it is still not yet ruled on Judicial Watch's historic lawsuit and case that would, if the court rules the way we expect it will, and the counting of late ballots in as many as 30 states. Judicial Watch has been on the forefront of litigation to stop the counting of ballots that arrive for days and weeks after Election Day. And our legal team specifically presented oral arguments to the Supreme Court in March in a specific case concerning Mississippi that counts ballots that arrive upwards of 5 days after Election Day. We have a case in California where they count ballots that arrive upwards of 7 days after the federal election day. In Illinois, it's 2 weeks after the election day. And there are several other states that similarly abuse the rule of law and voter confidence and invite voter fraud by having extensive extensions unlawfully beyond Election Day, in our view. And it looks like the Supreme Court is going to agree with us, but they haven't ruled. So this is, we had a big opinion day, as the experts call it, on Thursday of this past week. And, so my team and my colleagues here at Judicial Watch and I were kind of clicking on the web browsers, hoping that the Supreme Court uploaded our case or our decision. It's the Watson decision, and it hasn't yet. But they uploaded a bunch of other cases, which I'll get into later, or made decisions in other cases that I'll get into later. So it's likely, well, I shouldn't say it's likely, it's almost for certain we're going to hear next week. So they've got some big decisions on our case, the Watson case, which would, again, preserve Election Day and say you can't get ballots that, you can't count ballots that arrive late. There's a case about birthright citizenship. I think it should uphold the president's view and the common sense view that citizenship is limited to the children of U.S. citizens, more or less, here. There may be exceptions, but not the broad exception where every illegal alien who has a child here or someone who's just passing through and they have a child, the children become automatic citizens. I don't think that can be the law. I don't think it is the law. And I don't think it's the way those who wrote the 14th Amendment intended it to be. So I don't know what the Supreme Court's going to do. I don't think it's going to be a complete loss for those of us who support a strict reading of birthright citizenship. But we'll see, because I think to do that would be extreme judicial activism and more of a political decision than anything else. There's a case concerning, or two cases concerning transgender extremism. Males being allowed to play in female sports simply because the males designate themselves as female. I think that case is going to go the way of common sense, so that should be a good result. There's going to be a case about whether or not Congress can wall off from executive authority so-called independent agencies, right? And the case is called Slaughter, and we expect the court will find that the president has the right to control presidential appointees and the people who engage in executive functions. He's the chief executive. And so these so-called independent agencies like the FEC and agencies like that are going to be, I think, after this ruling, again, I'm not sure that we'll rule one way or the other, but I suspect, given the makeup of the court, that we're going to get a good ruling there that will preserve democracy, meaning the president who we elect actually controls the government, as opposed to these independent agencies that don't have the accountability that we should expect in a constitutional republic to the people voters put in office. And so those are some of the big cases. There's an election law case that I hope will expand the First Amendment. I'd have to kind of look up the notes on that to give you my detailed view on it, but I suspect the Supreme Court's going to rule in a way that increases the First Amendment rights for political parties and such. And then there's a case concerning whether the president can can fire a member of the Federal Reserve, in this case Lisa Cook, who there have been allegations concerning mortgage fraud levied against. And he said, "I'm firing you for cause." And now the Supreme Court's going to try to second guess his decision whether over firing her. I don't think it's appropriate for the court to second guess the decision, but we'll see what happens. And they're expected to kind of go on the side of Lisa Cook because, in my view, the Supreme Court just thinks the Federal Reserve, for political and economic reasons, should be immune to democratic accountability, which I don't think is a very constitutional approach. So those are the big cases off the top of my head. I'm sure there are others I'm missing. But in the meantime, there's other things that need to be done about election integrity. I'm talking about the Judicial Watch case that now before the Supreme Court that could end the counting of ballots that arrive late. And I suspect the court's going to rule in our favor, but we don't know that for sure. But if they do rule in our favor, it will, to me, highlight the importance of Judicial Watch's work, but also concurrently the failure of Congress. So as I expect the court will rule our way, and if they do, it will further highlight the importance of Judicial Watch's work. Quite evidently, obviously, 30 states could have their rules thrown out, or at least 15 of them in the least, depending on how the court rules. But in the meantime, concurrently, it kind of shows the failures of Congress to preserve election integrity. I mean, the Save America Act continues to be hamstrung by the Senate in terms of being passed. And it's not because I believe they need a filibuster-proof majority. It's because I believe Republicans in the Senate, as a majority, don't want to pass the bill. That there are enough Republicans who just hate Trump that they don't want to pass the bill. Now, conservatives have been pressing the Senate Majority Leader Thune to engage in what is called a talking filibuster. It means the filibuster still is allowed, but in order for it to actually be used to prevent consideration of the bill, a talking filibuster would require someone be on the floor of the Senate to talk. Remember the Mr. Smith Goes to Washington movie? That would be the equivalent of the talking filibuster, that if whoever opposes the bill, Democrat or Republican, wants to stop the Senate from voting up or down, they have to maintain a filibuster as long as they're able to physically. And that's hard to do. Now, the Senate doesn't want to do that institutionally because senators don't like to work. They just don't like to work. Most weeks, senators come in and work for 2.5 days. They don't work on Monday. I think Monday is the fly-in day, maybe Tuesday morning. They work on Tuesday, they work on Wednesday, and they're usually out Thursday, meaning they usually leave Thursday afternoon. Is that what your job allows you to do? Do you get to just work 2.5 days and the rest is just yours to choose what to do with? I suspect not. And a talking filibuster requirement would would require the Senate to actually work, even on days like a Friday, let alone a Saturday or a Sunday. Yes, and even a Monday, as they consider this Save America Act bill, which, among other things, would enshrine voter ID laws, a voter ID law across the nation, so no states could exempt themselves, and also require citizenship verification beyond someone pinky swearing that they're a citizen in order to register to vote. It would require some verification of citizenship for new registrants. Americans overwhelmingly approve those two ideas, the voter ID and citizenship verification, by super large majorities. 80–90% of the country approves of those requirements. So why isn't it being done? Because of failures of leadership, not by just Senator Thune, because he's the leader, but he's also, he's basically a first among equals with his caucus. So if Republicans wanted it done, they'd get it done. President Trump, God bless him, he isn't backing down, and he's making them sweat a bit over these issues. For example, they've passed this, what I consider to be a big government federal housing bill that supposedly addresses affordability, but doesn't seem to, and probably is just an invitation, or based on my understanding, which is relatively informed, an invitation and an opportunity for big government meddling in housing. I mean, I don't know about you. I hear federal housing, and that's the end of the conversation for me. I know where I stand on, quote, federal housing. I'm against it. And so it passed by large majorities in both the House and the Senate, and President Trump was supposed to sign it this week. Instead, he said, I'm not signing it until the SAVE Act gets passed, which has driven D.C. crazy. Because all the Republicans on the Hill, all the Democrats on the Hill wanted this passed so they could go back at home and say, hey, look, we're addressing the so-called affordability crisis with this fake law. They don't say fake law, with this law here. And Trump said, no, I'm not going to sign it. Now, he'll probably eventually sign it, but many now are calling on President Trump to veto it until a SAVE Act is passed, until voter ID and citizenship verification is passed. So, as we wait for the Supreme Court, I encourage you, in the meantime, to let your views be known to both the Senate and the House. You can call the Capitol Hill switchboard, 224-3121. Ask for your senator or senators. Ask for your member of Congress in the House, and let them know what you think about the Save America Act and what the priorities of Congress should be. And you should also call the White House. I think the White House number is 202-456-1414, and express your views on the president's strong statements in favor of the Save America Act, and let them know what you think he should do in order to get voter ID done. All the reasons you're hearing about not having voter ID and citizenship verification and the other requirements of the Save America Act, they're all excuses. They're not reasons. And I'll tell you, our country's on the line when you're talking about having secure elections. Our elections are not secure enough because of the lack of voter ID and citizenship verification. So I encourage you to take that activism. I'm not telling you what to say. You're big girls and boys. You know what to say. Be polite. Let them know what you think about the Save America Act. Let them know what you think about voter ID and whether we should actually have laws with teeth, or a law with teeth, that prevent non-citizens from voting. And express your views to the White House as to what the president's been doing and what steps he should take next to ensure that the law is passed. But you can be sure in the meantime, as Congress dithers, stalls, hems, and haws, your Judicial Watch will continue with the heavy lifting for election integrity and free and fair elections by, again, pushing to ensure that there's no counting of late ballots, pushing to clean up the rolls, and taking other steps to preserve and push for fair and cleaner elections with common sense election security measures. Now, the Supreme Court issued several decisions. It's June. So June is that time of year where our republic is either strengthened or weakened by actions of the Supreme Court. Thankfully, we've had the republic largely strengthened by actions of the Supreme Court due to the fact that there are conservative jurists that have been appointed over the years by presidents, including the current president, President Trump, that keep on affirming the rule of law, protecting our republic from intervention and hijacking of our rights of self-government from rogue activist judges, and who seemingly try to fairly apply the law. Now, in many cases, you may not know this in June, there are many cases that are 9-0, where the liberals and conservatives all agree this is what the law is, this is what the Constitution requires, as best as we're able to tell. But there are several cases, and I've gone through them with you already, where the justices diverged, generally speaking, by ideology. That's not always the case. But more or less, you have these 6-3 cases where the conservatives are in the majority of 6 and the liberals are in the minority of 3. And we had 3 or 4 of those, I think 4 of those cases, more or less, maybe just 3, because one case had a conservative in the minority. I'm not going to go through the cases in exacting detail with you, but I want to give you enough detail so you know what they're about. Because if you listen to liberal media, they won't tell you what they're really about. They characterize them in a way, to make it seem like the conservatives are doing something wrong. There were 2 cases that upheld, and this is important, because we've had, I don't know, maybe you've missed it. I doubt you have, because the media and much of D.C. likes to pretend it hasn't happened. Thankfully, President Trump and some of his appointees haven't forgotten. We've had an invasion of the United States over the last several years by illegal aliens. And President Trump and his team have been trying to reverse the invasion, and they've been thwarted time after time by outrageous acts of defiance by judicial activist judges. And thankfully, the Supreme Court has issued at least 2 decisions that will allow President Trump to reverse the invasion in a more significant way. One, just in case he needs to take additional steps, and the other is an immediate issue that he needs to address and he's trying to address. The immediate issue is something called temporary protected status. Temporary protected status was a law passed, I think it was around 1990 or so, that allowed the presidents and the Secretary of Homeland Security, or the responsible official at the time, I don't think we had Homeland Security at the time, to make a determination about a country and provide temporary protected status to individuals from that country to remain here. And the whole point of it is it's temporary. And once he or she makes the determination that the conditions in the country don't mandate or warrant allowing people to reside here in the United States, they have to go home or to a third country. They no longer have lawful presence, or will no longer have lawful presence once the TPS structure is eliminated, or once the TPS determination is undone. And some countries have had TPS determinations that have gone on and on and on for decades. So as Justice Alito noted in his majority opinion, temporary protected status has resulted sometimes in the status continuing for decades. Let's go to, I'll show you the section of his opinion where he describes this. Although designed to afford temporary relief, TPS designations in practice have often lasted for decades. For example, the Secretary designated Somalia in 1991, and that designation remains in effect 35 years later. 3 other countries retain designations that are more than 25 years old. Although he notes in a footnote, which I think is interesting, that there are 3 countries where there was a brief TPS designation or determination. in Lebanon, terminated 2 years after initial designation. Rwanda, terminated 3 years after initial designation. And Montserrat, terminated less than 8 years after initial designation. I got to confess, I thought Montserrat was a city, not a country. So I guess I don't know everything, right? And so the big fight is, after President Trump made it clear he generally opposes this scheme and scam that is just a backdoor amnesty for hundreds of thousands of, in the case before the court, Haitians and Syrians, he said no more. And the secretary said there's no more reason to allow these designations to continue. And the big dispute is whether or not the court can second guess the determination to either institute or end temporary protection designation for a country that allows, again, its residents, its citizens to reside here in the United States without being deported. And the president said no to Haiti, no to Syria, and he's likely to say no to any other temporary protected status designation that gets renewed in his term. So they're up for renewal every 18 months. So you know what the left did. They went and sued. And you know what happened with leftist anti-Trump judges. They immediately said, oh, no, you can't do this. Even though the statute that defines temporary protected status and how it's designated in a country, for a country by an executive branch official, it's immune from being reviewed by the judiciary. Congress said the judiciary can't review the determination. And somehow these courts said, well, that doesn't matter. And here the Supreme Court said it does matter and you're not allowed to do it. And the only other way they could have possibly gotten around it, according to one theory, is that the president did it based on improper purposes. He was being racist and attacking Haiti as a terrible country. He used much more vituperative language than I am. And just generally attacking these countries as you know what whole countries, right? And they said, well, that's racist, and therefore you can't change temporary protected status or end it for Haitians and Syrians as a result. And the Supreme Court said, well, that's ridiculous. First of all, his statements were not, quote, racist in the way you suggest they were. He generally opposes the whole process. So there's no judicial determination, and the majority found that there's no constitutional lapse that would allow anyone who's affected by this decision to challenge the president or to challenge the determination. So a really simple case. But it could result in hundreds of thousands of people having to leave the country, which is what the law requires. I'm old-fashioned when it comes to the immigration problem. It's like we don't need reform, we just need to enforce the law as written. And the law as written affords the president unreviewable authority to determine temporary protected status for foreigners here in the United States based on the conditions in their home country. And the left says the law doesn't matter. And Justice Alito said it does matter. And in fact, Justice Thomas said, not only is it unreviewable, but just because you might think Trump is racist or it's unfairly determined because someone doesn't like the country, Justice Thomas says, well, that's too bad because it's unreviewable and in the sense that, the idea that because you're from Haiti or Syria, that you can raise a claim of discrimination based on national origin in the president's determination whether to let you in or out of the country It's absurd. The whole world can't file a civil rights lawsuit against the president. And that's what the left wants to do, because that's their way of destroying any border security. So Justice Thomas's decision is well worth reading. And I encourage you to read the decision that I'm talking about here and the other ones I'll talk about, because they are accessible to the layman. I'm reading them. I'm a layman. I understand them. Some of them are a little bit thick sometimes legally, but I encourage you to read them. And you'll just see not only how sensible the majority opinions are, they're now being excoriated by the communists who seemingly are controlling our media these days, but how extreme the dissents are who are put on the court to uphold the rule of law, but seem to let their politics get in the way of upholding the rule of law. And plus you can read really based decisions, as some like to say, from Justice Thomas, who says, yeah, I agree with the majority, but I would go further. And so read the decisions. We'll post links to them below for you. Another important Supreme Court decision on immigration was, it's another seemingly simple one. So the left got angry that temporary protected status was deemed to be, quote, temporary by the Supreme Court. And the left is also upset that in this other decision, that the Supreme Court determined that when the law says you can get asylum or make a claim for asylum if you arrive in the United States, that doesn't mean you can claim asylum if you arrive in Mexico. See, this is, I mean, it's one thing to be fighting about these core constitutional issues that we all know about, like we'll talk about the Second Amendment later. But here we're doing the legal equivalent of arguing about whether the sky is blue or not. And the left has decided the sky is not blue, and the Supreme Court has to waste time, resources, and in the meantime, the rule of law is undermined by judges who try to interfere with the administration of the executive branch under the president's constitutional authorities over whether the sky is blue or not. So our asylum laws require the government to consider claims of asylum of anyone who's in the United States. So what Trump had done, he's not doing it now, but he wants to be able to do it in the future if the situation warrants, is that he's prevented people in Mexico from entering the United States in order to make asylum claims. And the left said, no, 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 no. You can't do that. They're in the United States for purposes of law, even though they're in Mexico. And again, Justice Alito and 6 justices of the Supreme Court said that is the most absurd thing we've ever heard. And I'll read you the first few lines of Justice Alito's majority opinion. And I really can't improve upon it beyond this. I encourage you to read the whole thing. This case presents a straightforward question whether an alien who seeks to enter the United States from Mexico arrives in the United States when he or she is still in Mexico. In the decision below, which was the Ninth Circuit Court of Appeals, that's the court below the Supreme Court, the United States Court of Appeals for the Ninth Circuit answered, yes, that is wrong. In ordinary speech, no one would say that a person arrives in a place, for example, a house, a city, or a country, before the person enters that place. The context in which the phrase arrives in the United States is used in the immigration statutes at issue here supports an ordinary meaning reading. So does the presumption against extraterritoriality. We therefore reverse. I mean, I hate to use the analogy, but we've all seen movies, right, where, oh, the person's got to get asylum, but he has to get into the embassy, and the bad guys try to keep them from getting into the embassy. That's the common sense understanding of what being in a country or in a place where the country controls, in the case of an embassy, means. So the left would have you believe, as long as you're in Mexico, you can apply for asylum in the United States. And so you can read the decision, and Justice Alito explains the definition of in, and the dissenters say in doesn't mean what everyone thinks it means, and you can decide who's right. But I mean, my gosh. So it was a big deal in the first Trump administration because he was trying to end the crisis on the border because people were overwhelming the border, and the thinking of the government at the time was we're just going to let everyone in if they want to seek asylum. And Trump said, no, we're going to extend the border protection and prevent people from crossing the border. And yes, some can come in to get asylum or make an asylum claim, but we're going to do it in a regular, orderly, metered fashion. So thankfully, President Trump has essentially closed the border, so we're not facing that crisis, but he may need to have it available to him again in terms of preventing people from crossing the border and overwhelming and breaking our asylum system, which is already broken in many ways, but that's another matter. So a great common sense decision again from the Supreme Court. So, but a big victory for President Trump, because you would think, based on all these court decisions below, whether it be on temporary protected status or the asylum claims, that he's the devil incarnate for enforcing immigration law as written. And there's no way under law he should be able to do it. And they used smears against him, suggested he was being lawless and outrageous, when in fact all he was doing was enforcing the laws as written. And the Supreme Court affirmed President Trump's approach on, again, just enforcing the plain language of immigration law to protect our country and to reverse the Biden invasion. Another big case is this Hawaii case where, in response to various Supreme Court rulings affirming Second Amendment rights to citizens, Hawaii passed two laws that I think are terrible. A series of laws, most of which I think are terrible in terms of Second Amendment rights. But most specifically, that prevented someone, Hawaii didn't really want you to have any arms. They didn't want you to have a concealed or the ability to carry a weapon. I think for years they, according to the court, Hawaii issued firearm carry license only in exceptional cases. Indeed, it appears from the year 2000 to 2018, only 4 such licenses were issued. Well, the Supreme Court said the Second Amendment applies at the federal level, and the states need to follow it as well and respect the Second Amendment rights of citizens. And it's not just the Second Amendment, by the way, it's the 14th Amendment, too, that protects your Second Amendment rights. So these are 2 core civil rights sections of our Constitution that are being enforced by the Supreme Court and applied against left-wing states who want to disarm the population and hate the civil rights, the Second and 14th Amendment civil rights of citizens. And what Hawaii did after those Supreme Court decisions validating and vindicating the Second Amendment rights of citizens, they rewrote their laws to prevent anyone from being able to carry a weapon onto private property without prior and express permission. Now, obviously, a private property owner can say, I don't want weapons here. And they have a right to make you keep your gun aside or disarm before you enter a supermarket or somewhere else. But the idea that the state could essentially require permission is at odds with our history. No laws regulating firearms ever went that far, as this decision highlights. The only laws similar that the defenders could find were essentially 2 sets of laws. There were laws in the 19th century, maybe even the 18th century, that prohibited people from going onto other people's enclosures or properties and hunting. So they were essentially anti-poaching laws. You can't carry guns and hunt. So the purpose of the law was to prevent illegal hunting and destructive hunting on someone else's private property. It wasn't a broad law to prevent people from carrying guns to and fro. The other set of laws that Hawaii and the left has embraced were laws designed to keep blacks from owning guns in the days after the Civil War. Yes, believe it or not, that's what they were telling the Supreme Court justified Hawaii's decision to prevent essentially anyone from, practically speaking, being able to carry a firearm around. And Justice Alito and 6 of the justices said that's ridiculous. There was no similar law during the time the Second Amendment was deemed to have protected the rights of citizens to keep and bear arms that would have prevented them from basically walking around with guns, bearing them onto other people's property. Again, it doesn't prevent you from saying, I don't want guns on my property. But Hawaii thought they were going to do this one neat trick, right? Hawaii and New York and a few other states. Oh no, you now need permission to go onto someone's property if you're armed. And Alito said, no, that's not the law. You know, and he described a case of a woman. He did a hypothetical case. Let's say a woman is afraid of her boyfriend and she buys a gun. She goes to the gas station, or she goes to the supermarket, she goes to work, and none of those places have explicit permission to bring a gun onto the premises. And she has to disarm herself repeatedly through the day, despite being concerned about her personal safety. It effectively steals her liberty in terms of being able to defend herself with this obviously broad law to prevent citizens, in a way never done before in American history, from exercising their Second Amendment rights. So this is a great decision for the rule of law, the Constitution, and your civil rights. I encourage you to read it. The fourth decision is a little less interesting, but interesting nevertheless. This is a decision concerning Roundup. You may have seen commercials by the plaintiff lawyers on television soliciting clients for Roundup. Roundup is a pesticide that the plaintiff lawyers suggest is dangerous because of a particular chemical in it. I'm not going to tell you what the chemical is. I'm not going to get into the details there. And essentially, they've decided the way. So Roundup is allowed to be sold. Okay, the EPA under federal law has examined the pesticide, found it to be safe and suitable for commercial use and sale. And what the plaintiffs' lawyers decided, well, we'll just work with states and say that they're not giving enough warning to people on the allegedly cancer-causing chemical in them under state law. And Roundup said, and Monsanto or Bayer, the companies behind Roundup, said, we can't do that. Federal law doesn't allow us to put these extra labels on that A, may not be valid, and B, only the feds can agree to. So we're between a rock and a hard place, because you're asking us to add labels that the federal government doesn't allow. And what's happening is that these cases have been proceeding in state courts, I think by the hundreds, and could destroy the company. And the Supreme Court looked at the decision, looked at what's going on here, and they said, look, the EPA has this very stringent law or a program for pesticides. The federal government designates the EPA as the judge of what goes on these pesticide labels, and that's good enough. And states that add extra requirements are preempted from doing so. So if the plaintiff lawyers want to go in with silly science, in my view, and try to extract giant jury verdicts or settlements from the makers of pesticides, they're going to have to do it based on not a fanciful state law that requires something that federal law doesn't require. The left is upset because the plaintiffs' lawyers give money to, or big funders of leftist candidates in the states and at the national level. So they're all angry about it. And I encourage you to read the decision, namely because I think you should read Justice Thomas's concurring opinion that says that the law creating the EPA ability by Congress to regulate pesticides is beyond the powers of Congress. So I encourage you to read his base decision, which I largely agree with as well. So some good news out of the Supreme Court. We're hoping for better news, or even better news, next week. So I wanted to spend some time on this because no one else is going to tell you about these cases, or at least the way I do, for better or for worse, right? And again, you can read the cases below, and I encourage you to read all Supreme Court cases as they're issued, even the ones that seemingly are boring. They are usually very educational in terms of the rule of law and our Constitution. Our Constitution is what protects our liberties in large measure. And so, you follow what Congress does, you follow what the president does, you also got to follow what the Supreme Court does as well, because that's the way the Constitution set up our governance. So we have new Clinton scandal documents. These from the FBI from 30 years ago. You're not going to believe this story. So when Hillary Clinton's younger brother, Tony Rodham, passed away in 2019, he had been involved in various scandals associated with the Clinton presidency, et cetera. And so we asked the FBI for materials on Tony Rodham. And they ignored us. And then I think last year they said, well, we have found all these documents. Do you still want them? And we said, of course we do. And then they ignored us, so we sued. We finally got some documents from the FBI about Tony Rodham, and this is just a small number of the documents they found. And they confirmed that Rodham was subject to a criminal investigation in 1996, now 2026. So he was involved in an operation to bring import cars from Romania to the United States. And according to the FBI documents, it looks like the whole thing may have been a scam. So, and of course, it's so typical Clinton, right? And, Rodham has quite the reputation, but we'll get into that. So we got only 77 pages of the documents that they looked at thus far. Of course, they're heavily redacted. So here are the documents. So this is what it looks like when we get a FOIA document or a group of documents. There's the Department of Justice. So we got these documents last month. We got 260 pages that were reviewed, and 77 pages, or 76 pages, are being released. And then they go in, they give us the reasons why they're hiding the records. And then you see all the records that we aren't getting here, referred for consult, that says. And then they start giving us the records. And you can see some of them are blank. This is a blank record. I'll bring it out so you can see that it's a blank record. So you have to go down here before we get to the substance. And you see some of these initial records look to be investigative documents about Rodham's properties and addresses and things like that. We filed the lawsuit in December of 2025 after the FBI failed to respond to a 2019 FOIA request. And I don't even know if we would have sued if they didn't say, hey, do you want the documents still? It's like, oh, well, thank you. Yes, we do. We have thousands of requests. We can't sue on every request. But when the FBI reminds us, or the Justice Department reminds us, hey, you've got this request, you still want it, we're like, oh, yeah, that was a great request. We should get those documents. In August of 2019, after we filed our initial FOIA, The FBI acknowledged it had located over 13,000 pages of records responsive to the request, as well as audio and video files that are potentially responsive. After years of delays, in May of 2025, the FBI again acknowledged possession of the responsive records and asked if there was still interest. Judicial Watch acknowledged its continued interest in having the request processed without modification of its scope. Having received no further response from the FBI, Judicial Watch filed suit. So what the record, so there's this core company, or Romania at the time, in 1996, was making cars called ARO. I think it's Automotive Romania, it's short for. And the records concern a scheme in which Rodham and two associates had set up an operation to import and find dealers for the cars. And that's what the FBI was looking into. And it looks like there was some type of fraud going on, at least based on the material that the FBI produced to us. Although it's not clear, because it's just, an investigation. They're not saying there was fraud per se, but there was enough evidence that they wanted to figure out what was going on. But because it was Tony Rodham, who at that time, who was president in 1996? Bill Clinton, Hillary Clinton. What was 1996? An election year. So according to the document, the case has assumed sensitive political aspects because it has been determined that Anthony Tony Rodham, a brother of Hillary Rodham Clinton, may have played a role. So here's the big document that I'm referencing, or record, or whatever you want to call it. Okay, so here it is. This is a 620 document, 1996, from the Miami field office of the FBI to other offices. And so this is a pretty comprehensive investigation, the way I read this, and you can read it yourself and interpret it any way you, well, hopefully interpret it yourself. But they're asking all these other offices to help them with the investigation. You'll see later. Synopsis. Leads set at receiving offices to contact and interview car dealership owners who deposited monies with subjects for the purchases of American franchises to sell Romanian four-wheel drive vehicles known as the ARO. ARO. I don't know how it's pronounced. ARO. Captioned matter is an investigation involving a solicitation by subjects blank and blank of auto dealers throughout the United States. Blank and blank own and operate East European Imports, Inc., a U.S. company from corporate offices located in Coral Gables, Florida. They have allegedly made claims to prospective dealers that EEI, the company, has the exclusive American rights for the importation of two models of a Romanian four-wheel drive vehicle known as the ARO. Questions have now arisen as to whether, in fact, EEI has ever had a legitimate contract with the Romanian government and or with the Romanian manufacturer exporter of the ARO to import these vehicles to the U.S. The investigation has assumed, there it is there, I'm going to highlight it there. The investigation has assumed sensitive political aspects because it has been determined that Anthony Tony Rodham, a brother of Hillary Rodham Clinton, may have played a role in securing the alleged ARO importation rights on behalf of EEI. Rodham traveled to Romania with blank and met with Romanian officials in this regard. There are credible allegations. Rodham was directly told that blank and had submitted fraudulent and inflated financial statements to Romanian authorities in order to support EEI's credibility as a viable importer of the ARO. Despite this notification, Rodham has purportedly continued to promote EEI to the Romanian government as a legitimate importer of these vehicles. And then it goes on to describe maybe that they were, fraudulently getting money from from dealers who were trying to get in on this car importation plan. So it's not clear to me, based on this document, whether Rodham was a subject or not. But it's clear he's implicated potentially in criminal conduct here. And the FBI is investigating it. And they were investigating it during the Clinton administration. And we're only finding out about it 30 years later, thanks to Judicial Watch. And it wasn't just a note, hey, by the way, Rodham may have been involved. They directed their colleagues in the FBI to ask the dealers who were being solicited, evidently, for deals and being asked for monies to be part of this program, if they had interactions with Rodham. Because later on in the document, I don't think we noticed this in the press release, but it's later in the document, all receiving offices, so I listed all those offices, you saw that. Let's go back to the all receiving offices there. Atlanta, Baltimore, Charlotte, Cincinnati, Columbia, Jacksonville, Louisville, Memphis, Miami, New Haven, New York, Norfolk, Philly, Pittsburgh, Richmond, Tampa. WMFO, I think that's probably the DC field office. So that's 1, 2, 3, 4, 6, 9, 12, looks like 17, 18 offices. So this is a national investigation involving Hillary Clinton's brother by the FBI that is only being disclosed to you now by Judicial Watch as a result of a lawsuit that Judicial Watch filed for documents we first asked for 7 years ago. And this investigation is in some ways ancient history. It's 30 years old. So they asked all receiving offices should contact the auto dealers identified in the lead section, following and conduct an in-depth interview to determine the nature and extent of the dealer's business contacts with blank or any other representatives of EEI. Any documentation concerning the business transactions between the dealers and EEI, including contracts, canceled checks, or other correspondence, should also be obtained. Identify any other employees at the dealer's business who had contact with representatives of EEI and interview those employees for additional pertinent information. Here's the kicker, another kicker. Due to the sensitive political nature of this investigation, blankety blank, 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 at this time, Miami does not believe Rodham's alleged support for EEI in Romania has extended to personal contacts with individual auto dealers. However, dealers should be specifically asked blankety blank, 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 blank. Any voluntary response, which includes Tony Rodham's name, should be thoroughly explored. Should information about Rodham be developed, interviewing agents are requested to immediately contact Miami case agents. And then they ask them to ask the following questions, which of course you can see all those questions are redacted. All that white space is redacted. So it sounds like it was a big deal. So they were investigating Tony Rodham, and they were very interested to know if his name would pop up among dealers. Now, we don't have all the documents, so we don't know what happened with this case. Well, we do know what happened in the sense that there was no prosecution of Tony Rodham for this, right? And I think these documents, as I say in the press release, what do I say in the press release? So after 3 decades of delay, these FBI records reveal a criminal investigation involving Hillary Clinton's brother and raise serious questions about remains hidden in the government's files, not only about Hillary's brother, but Hillary Clinton herself. So despite this case going back a long ways, it's kind of consistent with Rodham's reported efforts to leverage his name and his connections to the Clintons, as Judicial Watch has exposed in other cases. And you gotta wonder if this investigation was suppressed in any way for political reasons, because it implicated Hillary's brother, or given the fact he was talking to the Romanian government and raised foreign policy issues. And there have been other scandals involving the Clinton brothers with foreign policy, but This is the first one, or the first one where we've got details in my recollection. I'm trying to think of the hazelnut scandal. Those of you start Googling it, you'll see what I mean. I don't think that was criminally investigated. Maybe it was. But this is a criminal investigation concerning Hillary's brother, and the FBI is very interested in his involvement. Was it shut down? I don't know. What was found? As Judicial Watch notes in our press release, Rodham for decades used his connections with the Clintons to further his interest. Rodham described himself as a, quote, a facilitator, and had a range of opportunities like addressing Chinese investor conferences and joining an advisory board of a company seeking permission to mine for gold in Haiti. Among other controversies, Rodham also pursued contracts in post-earthquake Haiti, seeking a $22 million housing deal while Bill Clinton co-chaired the Recovery Commission, a proposal that collapsed. While Hillary Clinton was Secretary of State, former Virginia Governor Terry McAuliffe, who's a Clinton crony, and Rodham were involved in a controversy over their involvement in the EB-5 Cash for Visa program, in which they raised at least $46 million from investors for their Green Tech automotive electric car company. Green Tech filed for bankruptcy in 2018. So you can see that if you're kind of construct a case of corruption against Hillary Clinton, this is the sort of information you would want to have. I'm not sure where it would have led if the FBI investigated it or how far the FBI investigated it. But Hillary Clinton has a consistent record of allowing her friends and family to use her office, and Bill has this record as well, for their personal benefit. Remember, he was using the White House to raise money from Chinese generals. I mean, that's the most, I think, one of the nastiest examples of it. So what were the Rodhams doing? What was Tony Rodham doing in Romania? And what did Hillary know? When did she know it? Those are the types of questions these new documents raise. And without Judicial Watch persistence, over years, are we only able to get these documents now? Why do I think it's still important? Because I think Hillary Clinton is still a political figure. I still think she wants to be in power. And the more we know about what she was up to, the better off we are in terms of voters knowing what candidates have done or potential candidates have done in government service. Now, Judicial Watch, of course, uncovered the Hillary Clinton email scandal, and the consequences of that scandal for Hillary Clinton was she lost the presidency. So we already know Judicial Watch's work. The consequences of Judicial Watch's work are historic, and this kind of is in that same category. So you can go look at the full set of documents on judicialwatch.org, the link specifically below for you. One of the reasons I love Judicial Watch, other than being its president, is because as a citizen, I am continuously impressed, and I hope you are too, that we are kind of into everything when it comes to government corruption, the rule of law, and our Constitution. We've talked about the Supreme Court. We have this big case on election integrity that's about to be ruled on any minute. We have involvement in virtually every corruption scandal in terms of investigating, uncovering, and trying to get accountability for them. And to that end, we have this big case coming out showing that Hillary's brother was the subject of an FBI investigation during the Clinton administration, and no one knew about it. And I have a feeling no one knew about it for nefarious reasons. And this is, again, the result of decades of Judicial Watch persistence and work, and it's only possible thanks to your support. So again, I encourage you to support Judicial Watch in any way you can, hopefully with a donation. Otherwise, just share the wealth of information I'm sharing with you on this program and other programs. Go to judicialwatch.org and make your most generous donation today. I'll see you here next time on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.